Welcome to the Deep Dive. Today, we're digging into a really significant area of American law and society, the constitutional right to abortion.
That's right. And we'll be tracing how it evolved, focusing on three really crucial Supreme Court cases.
We've got Roe v. Wade, of course, from '73.
Then Planned Parenthood v. Casey in '92.
And the most recent major shift, Dobbs v. Jackson, Women's Health Organization from 2022.
Yeah, our goal here is really to map out how this right was established, how it was later, modified, and where we are now after Dobbs.
It's quite a journey, seeing how the court handled such a deeply personal issue through the lens of the Constitution.
Absolutely. These cases are like signposts marking major shifts in legal thinking.
Okay, let's start at the beginning then. Roe v. Wade, 1973. This is the big one, the case that established that nationwide right. What was the core reasoning?
Well, in Roe, the court basically said that a woman's decision whether or not to have an abortion is protected by the Constitution.
But the word abortion isn't actually in the Constitution, is it? So where did they ground that right?
No, it's not explicit. The court located it within the right to privacy. They argued this right to privacy, while not spelled out word for word, is implied within the Due Process Clause of the 14th Amendment.
The Due Process Clause. Remind us briefly what that covers.
Sure. It fundamentally says the government can't deprive someone of life, liberty, or property without, due process of law. It prevents arbitrary government action on basic rights.
And the Roe court saw the abortion decision as falling under that liberty and privacy umbrella.
Exactly. They viewed it as part of a zone of personal privacy, free from excessive government interference.
It wasn't an absolute right, correct? There were limits based on the stage of pregnancy.
Precisely. That's where the trimester framework came in. The court tried to balance the woman's right against the state's interests.
Which interests?
Two main ones: protecting the health of the pregnant woman and protecting the potential life of the fetus.
Okay, so how did the framework break down? First trimester.
In the first trimester, the court said the state's interests weren't compelling enough to interfere much. The decision was largely left to the woman and her doctor.
Minimal state role early on. In the second trimester.
In the second trimester, the state's interest in the woman's health became more significant. So states could enact regulations, but they had to be reasonably related to maternal health.
Okay. And the third trimester, that's when the fetus might be viable, right?
Yes, post-viability. That's the point where the fetus could potentially survive outside the womb.
Viability meaning it could survive, maybe with medical help?
Correct. At that stage, the court said the state's interest in potential life became compelling, so states could regulate or even ban abortions.
But there was still an exception.
Yes. Crucially, there always had to be an exception to protect the life or health of the mother, even in the third trimester.
It sounds like a very structured attempt to balance complex issues.
Yeah.
But I remember it faced criticism.
It did. A key criticism was that the trimester lines were too rigid, almost like medical rules set by judges. Some felt the court was acting more like a legislature than, interpreting law.
Right, making policy. Okay, so Roe establishes this framework. Fast forward nearly 2 decades, 1992, Planned Parenthood v. Casey. What's the backdrop here? Was Roe in danger?
The court's makeup had changed, and there was definitely pressure and speculation about overturning Roe. Casey emerged as kind of a compromise, really. It was a joint opinion from the center of the court.
And what did they decide? Did they uphold Roe?
They reaffirmed what they called Roe's essential holding,
Right.
A woman's right to choose an abortion before viability. So that core principle survived.
But they changed the structure, didn't they? Moved away from the trimesters.
Exactly. They ditched the trimester framework, calling it too rigid. Instead, they introduced the undue burden standard.
Undue burden. What does that mean in practice?
It means a state law is unconstitutional if its purpose or effect is to place a substantial obstacle in the path of a woman seeking an abortion before the fetus is viable.
A substantial obstacle. That sounds a bit more flexible, maybe more subjective.
It definitely allows for more regulation than Roe's first trimester rule did.
Can you give examples? What kind of laws were okay under Casey and what wasn't?
Sure. The court upheld things like informed consent requirements, making sure the woman has specific information, and 24-hour waiting periods. They saw those as not creating an undue burden.
Okay, and what was considered an undue burden?
A key example they struck down was a spousal notification requirement. The court recognized that forcing a woman to tell her husband could pose a very real, substantial obstacle for some.
I see. So Casey tried to find this middle ground, uphold the core right, but allow more state regulation. Did it settle the issue?
Not really, no. The hope might have been there for some justices, but the debate remained just as intense.
And didn't Casey talk a lot about precedent, about stare decisis?
Yes, that was a major part of the joint opinion. They stressed the importance of sticking to precedent, stare decisis, and worried about the court's legitimacy if it just flipped its position on such a major ruling like Roe.
Which makes the next case, Dobbs, even more striking. 2022. What led to this after Casey seemed to cement things, sort of?
Well, the biggest factor, again, was the composition of the court changing over the subsequent decades. Particularly after Justice Ginsburg's death and Justice Barrett's appointment, there was a clear majority seen as willing to revisit Roe and Casey directly.
And the Dobbs case involved a specific state law from Mississippi.
That's right. Mississippi passed a law banning most abortions after 15 weeks of pregnancy.
15 weeks. That's well before viability, as understood under Roe and Casey, isn't it?
Yes, clearly before the viability line. So it was a direct challenge to the core holdings of both previous cases.
And the court took the case, and what was the ultimate outcome?
The ultimate outcome was monumental. The court explicitly overturned both Roe v. Wade and Planned Parenthood v. Casey.
Completely overturned them. Wow. What was the majority's reasoning for such a dramatic move?
The majority opinion essentially said the Constitution makes no reference to abortion and therefore confers no right to it. They argued the right wasn't deeply rooted in this nation's history and tradition.
So rejecting the privacy argument from Roe.
Yes. They concluded that Roe and Casey were, in their words, egregiously wrong and represented judicial overreach. They stated the authority to regulate abortion must be returned to the people and their elected representatives, basically back to the states.
Egregiously wrong. Strong language. Were there other opinions?
Yeah.
Concurrences? Dissents?
Oh, yes. Justice Thomas wrote a concurrence suggesting the court should also reconsider other precedents based on similar substantive due process reasoning, mentioning rights related to contraception, private consensual sexual acts, and same-sex marriage.
That caused quite a stir. Did other justices agree with that broader view?
Not explicitly in their concurrences. Justices Kavanaugh and Roberts wrote separately, emphasizing that the Dobbs decision was specifically about abortion and didn't necessarily threaten those other precedents.
Okay. And the dissent. What was their main argument against overturning Roe and Casey?
The three dissenting justices, Breyer, Sotomayor, and Kagan, wrote jointly and forcefully. They argued the majority was discarding nearly 50 years of precedent, which they believed severely damaged the court's legitimacy.
What else did they highlight?
They emphasized the real-world consequences, saying the decision stripped away a fundamental right from women, impacting their autonomy and equality with disproportionate effects on women of color and those with fewer resources. They also expressed deep concern that it could indeed pave the way for challenges to other established privacy rights, despite the majority's assurances.
So Dobbs fundamentally reshapes the landscape.
Right.
No more federal constitutional right. It's back to the states.
Exactly. And that shift has led to a flurry of activity at the state level.
Especially through ballot measures, right?
Yeah.
We've seen voters weighing in directly.
Yes, that's become a major battleground post-Dobbs. Numerous states have had abortion-related questions put directly to voters on the ballot.
And how has that generally played out? Is there a trend?
Well, interestingly, the trend so far has largely favored outcomes protecting abortion access. In the majority of these initiatives, voters have sided with maintaining or establishing abortion rights in their state constitutions.
Can you give some recent examples?
Yeah.
Like from the 2024 elections?
Yeah, sure. In 2024 alone, voters in 7 states passed constitutional amendments to protect abortion rights. That includes Arizona, Colorado, Maryland, Missouri, Montana, Nevada, and New York.